So, question is that part 2 stand part? No, we're on to part 2. This is debate on clauses 9 to 10 and the schedule, and the question is that part 2 stand. Honourable David Cunliffe.
And this is a matter relating to part 2, and it seeks further clarification based on the ruling that you've just made, sir. And in respect of the antidote to repetition, where there
No, look, you're trifling with the chair. The member will sit. The member will sit. You're just wasting time. That's all that's happening here. I'm seeking someone who wishes to take a call. The Honourable Phil Goff.
Thank you very much, Mr Chairman. Part 2 has 2 clauses. The first, Clause 9, is a validation clause. And what Clause 9 does is validates the closing date for submissions on the proposed plan that was adopted by Auckland Council. And it also, under Section 171, validates any hearing sessions of a hearing panel that was held concurrently with another section. And I want to come back and focus particularly on that clause, but just to mention under Clause 10, that's about consequential amendments, and I've got a couple of questions about that as well. So what we're predominantly dealing with in this part, Mr Chairman, is validations. Now, validations has a nice sound to it, but what does it actually mean? A validation is what you do after the event to remedy a cock-up in earlier rushed legislation, to retrospectively justify what was illegal.
No, that's a word that's been ruled out. The member will not use that word. Honourable Phil Goff.
A mistake. A validation is what you do to remedy a mistake made in previous legislation and retrospectively justify what has been done illegally and without authority. And when we do these things retrospectively, we need to look at what lessons can be learned from how the mistake, if you prefer to call it that, Mr Chairman, was made. Now, I'm conscious that this clause validates changes, I think, that was made in the amendment bill that was passed 2 years ago. And the irony of what we're doing in the session today is that we are considering legislation which has not gone to a select committee. And let's think about for a moment what the purpose of taking legislation to a select committee is. It's on one hand to give the public input, to make sure you've got the solutions right and the experts' input, but on the other hand it's to allow the select committee to work in a bipartisan way to prevent mistakes being made in legislation. So what we would have done in a select committee is that we would have had the Parliamentary Council before us to make sure that the drafting was accurate. We would have had the officials before us to give advice, and unlike the House, would be able to cross-examine the officials. Now, I don't think that happened back in 2013, and the irony is that we are doing exactly the same thing again. We are rushing through legislation that has not been considered by a select committee, and I can guarantee, Mr Chairman, that we'll be back again to repair more mistakes that are made because we're once again passing legislation in haste. But I want to ask a couple of questions of the Minister and the Chair, and the first validation we're doing is the closing date for submissions to the Auckland Council of 28th of February 2014. So we're remedying a mistake that relates to events that happened 20 months ago. And the question that I have is, what are the implications of leaving it 20 months before you validate this piece of legislation that did not create the proper authority? And why has it taken 20 months to remedy this? This is something that should have been brought to the attention of the House much, much earlier. The second validation is something that has wider consequences, and that is, in this legislation that we're passing, it allows the independent hearings panel to meet concurrently. But what we find in Section 171 is that we also have to validate the fact that they have been holding these panels concurrently for potentially a long period of time. So my question to the Minister is, what is the scale of this mistake that we are rectifying in the House today? How long have those hearing panels been acting without legal authority to do what they have been doing? And what are the consequences of having left it so long to try to validate what the panels were doing without the authority of this House to do? These are significant mistakes. Yes, we're rectifying them. Yes, the opposition will support the government in rectifying this situation, but the House needs to know what are the implications and why it took so long.
I'm going to call